I'm gonna start answering Darlene's question, and I'm going to answer it by firstly explaining the position of monogamous customary marriage, and then explain the position of polygamous customary marriages. For monogamous customary marriages, the monogamous customary marriages are automatically in community of property, irrespective of whether they were entered into before the coming into operation of the act, uh, before and then after. But when the act was passed, only monogamous customary marriages which were entered into after the passing of the act were regarded as automatically income of property, and those which were entered into before the act had said that they continue to be administered by customary or to be regulated by customary law. This was challenged by Mrs. Gumete in the Gumete versus the President of South Africa, and the Constitutional Court declared that section that stated that monogamous customary marriages which were entered into before the coming into act, they declared that that provision is invalid and unconstitutional. As a result of that, you must know that all monogamous customary marriages are automatically in community of property, and then those which were entered into before the coming into act, uh, they only became out of community of automatically in community of property after the Constitutional Court declared them to be so. Now, when we come to polygamous customary marriages, the position differs as to whether the marriage were entered into before the coming into act and after the coming into the act. Those which are entered into after the coming into the act, the husband, in terms of section 7 subsection 6, is required to bring a high court application and to request the court to approve the marriage contract which will regulate his marriage relationship. If the husband does not bring the marriage relationship, the polygamous marriage, the first wife and the husband, their marriage is going to be automatically in community of property, but the subsequent wife, their marriage is going to be out of community of property. This basically means that a husband can be married with two wives, but have two different marriage regimes governing their marriage. This is because the Supreme Court of Appeal have held that if the husband does not bring in a high court application, this does not necessarily mean that the subsequent marriage is invalid. The marriage will continue to be valid as long as it was validly and all the requirements were followed. As long as it was entered into in compliance with the act, the marriage will continue to be valid, but the marriage regime is going to be different between the parties. But if the husband brings a court application and the court approves the marriage contract, then the terms of that marriage contract will regulate the proprietary consequences of this polygamous marriage. Also, you need to know that if the husband belongs to the Tsonga custom, and he enters into a marriage, a polygamous marriage, or he takes a further wife or further wives without bringing a high court application or without complying with section 7 subsection 6 of the act, this marriage, the subsequent marriage is going to be automatically null and void. This is because men who belong to the Tsonga custom, before they can take another wife, they must get the consent of their spouses, of their wives. So if that consent is not obtained, the marriage with the subsequent marriage of the other wife will automatically be null and void. Okay, does anybody have any question on polygamous after they're coming into the act, before I talk about the position, before coming into the act. For now, the hands that I'm going to take are only those who are, sorry, they're only those who are going to ask about polygamous marriage after they're coming into the act. Ne? Okay, David Letswalo?
A follow up.
Morning, ma'am. I
Morning.
was not going to ask about polygamous. I was going to ask about customary marriage. In terms of one of the requirements is the two parties must consent. Let's say they've consented or they've agreed to get married, and in before concluding of the customary marriages of handing over the bride and doing that, and one of them decide, I don't want to be involved in this customary marriage or in this marriage anymore. How does one go through? How does one go about annulling that? Must we go through the court, or can we just call the families to sit together and say, okay, our kids does not want to go through with this thing anymore? Or how does it work?
Okay, I'm writing it down. I'll answer it
Okay, thanks, ma'am.
when I'm done here. Okay,
Thanks.
Alex?
Yeah, it's just a follow up clarity seeking
Mhm.
question, because when you presented on the Vatsonga culture,
Yeah. Mm-hmm.
who, a man will take the second wife, but as you rightly indicated that the consent of the first wife is very necessary. But I hear the statement in the textbook that says if the first wife withholds the consent, the man would not have any choice but to divorce that wife. Is it in addition to what you said that the marriage will be nullified? Because I
Yes.
see here that if it's something that was followed before, but the husband, because the wife cannot concur to the husband taking the second wife, it means that automatically that husband would divorce the wife.
Yes, remember, if the first wife does not consent, the husband cannot take another wife. So the only option that is left is the husband must divorce that wife and get married to whoever he now wants to get married into. But if the husband does not divorce the wife and further there he continues and enters into a marriage with another woman, that marriage will be null and void. The subsequent marriage will be null and void because the first wife would not have agreed or would not have given the consent. So for the husband to continue and get married to the other woman depends on what the first wife says. So if the first wife says, I don't want to, unfortunately, there is nothing that the husband can do. And the only option is not just divorce. There's also the option that the husband can maybe just continue in a relationship with the other lady, but not marry that lady, and the lady will just be a girlfriend indefinitely, or the parties can just terminate their relationship and the husband can continue with his wife. But for the Tsonga custom, you must know that the wife is the one who, I can say, holds the key for the husband as to whether he can continue to enter into another marriage or not. Okay, do you understand, Alex? Let's take Palisa.
Yeah, no, it's complicated.
Okay, Palisa,
Hello, ma'am. How are you?
I'm okay.
Okay, ma'am. Please write down my question also. It's not related to what you are saying now.
Okay.
I just want to know if you're gonna be touching on the HHP case, the Tsambo versus Sangadi, it's a 2020 judgment, and please, if we can discuss in terms of they don't recognize the handing over as a requirement, handing over the bride as a requirement, and also how they dealt with the celebration of the marriage. So that my question is, does it mean that only the lobola that it's considered? If you've lobola, then it means that you are automatically married. We no longer give a reference to the handing over and the celebration. Thank you, ma'am.
Okay, thank you. Okay, let me continue and talk about the position of polygamous marriages that were entered into before the coming into the Act. When the Act was passed, the provision stated that the position of polygamous marriages that were entered into before the Act continue to be regulated by customary law. This has been changed by the Constitutional Court in the case of Ramuhovi versus President of the Republic of South Africa, where they declared Section 7, subsection 1 of the Act unconstitutional. So the position now is, as proposed by the Constitutional Court, is polygamous marriages that were entered into before the coming into the Act. Distribution or the proprietary consequences I have to be dealt with. One, wives and husband will have joint equal ownership, management, and control over the matrimonial property dependent on the nature of the matrimonial property. Secondly, the wife of the house and her husband will have joint ownership, management, and control of the house. The property must be administered for the benefit of the particular house. This basically means that, when you talk about a proper polygamy, let's look at into the rural areas. In the rural areas, you'll find a husband who has a big land, and in that big land, there's the main house where he stays, and then there's these other houses where the first wife stays, the second wife stays, and the third wife stays. So this says that number B says that the wife in, let's say, house A, with the husband, they will have joint ownership and management and control over that house property. And then house B with wife number 2, wife number 3, and the husband. So wife who is in control of house number A is not in control of house number B, and then these two wives are also not in control of house number C. So this is not like the polygamy that we see in the urban areas where the husband and the wives and everything, they're staying in the same house. A proper polygamy, each and every wife has their own house, or they has their own houses, and there is the main house where the husband stays and where all his wife also have access to that. And number 3, the Constitutional Court says that all wives and their husband will have joint equal ownership, management, and control over the family property. The property must be administered for the benefit of the family. So this is the main house, which is the family house where the husband stays and where all these wives have equal powers over that main property. And lastly, the court said that each spouse retains exclusive right to her or his property. So if in each and every houses that these wives actually stays and administers, all the personal properties, the furniture and everything belong to that specific spouse. But the properties in the main house, which will say is where the husband stays, all the wives have equal control over it. The legislators have now passed the Recognitions of Customary Marriages Amendment Act, and it commenced from the 1st of June 2021. This act has now changed most of the provisions from the initial Recognitions Act. So how polygamous marriages are administered, it is now legislated, and it is now in terms of those acts. Monogamous customary marriages, it is now legislated that they are automatically in community of property. So does anybody have any question regarding polygamous marriages before we touch other aspects of customary marriages? Can I take it that we are all okay? Nkosi Zungu? Nkosi Zungu?
Yes, ma'am. Where I got confused a little bit by your presentation was when you said that you could have two marriage regimes.
Okay.
You know, I got very, very confused, especially if the husband has not gone to court to seek the change. You know, to seek the change of the antenuptial contract. You know, so I got confused when you said you could have two marriage regimes. You know.
Okay, let me explain that. Ne? In terms of section 7, subsection 6 of the Act, a husband or a man who wants to take a further wife and who got married from the year 15 November 2000 to date, before he can take another wife, he needs to bring in a court application and request the court to approve the marriage contract which will regulate his marriage. Remember, we said monogamous customary marriages are automatically in community of property. So let's say it is Thabo who is married to Lerato, and it's just the two of them, and their marriage is in community of property. If Thabo now wants to take Palisa as another wife, and he firstly needs to apply to court, and when applying to court, he must present the marriage, the drafted marriage contract, which will regulate his polygamy marriage. This is because firstly, polygamous marriages are not in community of property and cannot be in community of property, because in community of property is joint estate where it is 50-50. So where it is now more than two people, it cannot be 50-50. So if the husband does not bring in a court application, the Supreme Court of Appeal has held that polygamous marriage continue to be regarded as valid as long as it was properly entered into. But when it comes to the marriage regime, the husband Thabo and his first wife Lerato, their marriage will continue to be in community of property, and Thabo's husband and his marriage to Palisa will be out of community of property. So Thabo is married to Lerato and Palisa, but with Lerato, the marriage regime is in community of property, and with Palisa, the marriage regime is out of community of property. So this is a polygamous marriage involving three individuals. Let's assume it is the latest one who stay in the urban areas. They live in the same house, but there is two marriage regimes that regulate Thabo's marriage because of his failure to comply with section 7, subsection 6 of the Act. Do you understand?
Yes, I do. I am clear now because in the event of the division of the estate, the second wife will have a claim in the divided estate of the husband. I don't know if you understand me. From the reading of the material, it was said that that's where the second wife may have a remedy. I hope I'm clear.
Okay, the second wife, if the marriage is out of community of property, remember there is no division of the joint estate. The second wife will have a claim for spousal maintenance, but in customary marriages, irrespective of when the marriage was entered into, spouses are allowed to ask for redistribution of assets. So the second wife can have a claim over the estate of the husband if she gets an order from the court for the husband to redistribute some of his estate. But the challenge now is the husband's estate is a joint estate. It's an estate between him and Lerato. So when the court redistributes, that is where the challenge is going to be, because it will not only be taking from Thabo or the husband's estate, it will also be taking from Lerato, the first wife's estate, and Lerato is not espoused to Palesa. You understand? That is where the challenge is now with when the husband has two marriage regimes and there is a divorce. Unfortunately, now there is no a court judgment or a precedent that guides us as to how will the court deal with the issue where the subsequent wife is filing for divorce and is asking for redistribution of assets? Will the court claim from the joint estate of the parties, or will the court say we are only going to take from 50% share of the husband, and when the husband and the first wife eventually terminate their marriage, there will be an adjustment so that the first wife is not unduly prejudiced by the husband who did not comply with Section 7, subsection 6.
Thank you.
Okay. Anybody else? Okay. We can continue.
It's me.
Okay. Who's saying it's me? Who's saying it's
Alex.
me?
It's Alex.
Okay. Okay. You are done, Alex, right?
No, not
okay.
That. I just wanted quickly, when we were talking about Section 76, I just want to read one statement under that Section 76. Verbatim as it is. It says, if the existing customary marriage is in community of property or subject to accrual system, the court must terminate the matrimonial property system and effect division of property.
Mm-hmm.
Yes, just to
okay.
I just want to understand it, because vis-a-vis what we have actually explained
okay.
on that in terms of that section.
Okay, let's say the husband brings in a court application. So because the role of the court is to approve the marriage contract and is not to terminate the marriage. So the court firstly has to make sure that the division or the marriage regime of Thabo and the first wife, Lerato, it is terminated, and Lerato will be given her 50% share from the joint estate, and Thabo will be given his 50% share of the joint estate. And when the polygamous marriage now continues, is going to start on a clean slate with this court-approved marriage, the court-approved contract. So before the court can approve this contract that Thabo is saying this is what is going to regulate this polygamous marriage, the court firstly has to make sure that the current marriage regime that is regulating the what has been a monogamous marriage is terminated. So they just terminate and divide the joint estate, but the marriage, it is not terminated. Do you understand?
Yeah, no, thanks very much. Thanks very much. Thanks, it's clear.
Okay.
Thanks.
Okay. I'm going to answer the question of consent when one of the parties no longer wants to continue with the marriage. Firstly, it needs to be determined as to whether has the parties entered into a valid customary marriage or are the parties still in the process of entering into a marriage, meaning that they are still engaged? If the parties are still engaged, then everybody or each partner is free to let the other one know and the family that I no longer want to continue with the marriage. We have to note that engagement is a promise to get married, but it is not necessarily a marriage itself. And the law, as it states, anybody has a right to terminate an engagement without suffering any consequences. The only exception is if the parties had already progressed so far with their engagement, they had already spent money, and then termination of the marriage is going to result in economic loss. So the innocent spouse can sue the other party for the financial loss that has resulted from terminating of the engagement. But if the parties are already in an existing customary marriage, but one of the parties no longer wants to continue, then they need to file for divorce and terminate the marriage at court. We need to note that customary marriages can only be terminated by a court of law. Informal meetings by family members do not result in a formal terminated or in a legally recognized termination of a customary marriage. So I hope I answered your question, because it will depend on whether are the parties still engaged, or have the parties entered into a valid customary marriage. And if it's a valid customary marriage, informal separations are not legally recognized. The marriage must be terminated at court. There must be a divorce decree. Okay, Tsolofelo, please unmute yourself.
Yes, morning, ma'am. I just want to find out now if they have the court has registered has terminated the first marriage, and then the degree of divorce has been ordered. So does this mean then the husband is going to now share the remaining 50% with only the second wife, the one that he's going to marry using customary marriage?
Okay, firstly, we need to note that when the court terminates a marriage and a divorce decree is issued, you regain your status of being single. And then if you marry again, the marriage regime that you enter into will determine whether the spouse is going to get assets from your estate or not. So let's say in a polygamous marriage, the husband divorces with the first wife, but the parties decide to enter into a polygamous marriage, all three of them. So the question now is going to be, did the husband comply with section 7 subsection 6 of the act? If the husband did not comply with that, the first marriage is going to be in community of property, and that will be the first wife who was married. So if the husband divorces the first wife, and then let's say he enters into a customary marriage first with the girlfriend, and then subsequently marries the other woman who initially was his first wife, the girlfriend will now get 50% share from his estate, and the second lady, the initial first wife, her marriage will be automatically out of community of property. Understand? So what you need to understand here is, firstly, who was married first? Was the marriage entered into in compliance with the act? And did the husband also get a court approved contract before entering into a polygamous marriage? If he did not do so, then one, the first wife is COP, the other wife is OCOP. There is not even an accrual process, but if the husband gets a court approved contract, then that will regulate the marriage. I hope
Thank
you
you, ma'am.
answered. Okay, anybody else? Okay, let's continue. There was a question regarding the case of HAP, the Tambo case. The Tambo case relates to the requirements of customary marriages that were entered into after the coming into act, and more specifically, they relate to requirement number 3, which is the marriage must be negotiated and entered into or celebrated in accordance with customary law. The Supreme Court of Appeal had ruled that spouses can enter into or can have an informal handing over process. The facts of the HAP was that there was a celebration or a mini celebration that was done, but it was done from the wife's side of the family. Nothing was done from the husband's side or from the deceased side of the family. And the deceased family was arguing that we had not handed over this wife, or we had not regarded her as our wife, as our makoti, because the process was not fully complied with. The Supreme Court of Appeal did not agree with them, as in the case, as in the latest case of of Mbungela versus Mugabe, where they held that the handing over of the bride, it is not necessarily a key to a marriage being regarded as a valid customary marriage. So the question now is, if a man pays half lobola or just pays lobola and nothing else is done, can that be regarded as a valid customary marriage? And the answer to this will depend on a case-by-case basis. It's going to depend on what is the agreement between the parties. Have the parties and the family members agreed that we are going to either have an informal handing over, whereby we just agree verbally that after the payment of this lobolo, we are going to give our blessings and agree that the parties can either continue living together if they were in a cohabitation relationship and live together as husband and wife, or if they were not living together, we release them to start living together as husband and wife. In other cases, the parties can agree that after the payment of this lobolo, there is still some process that needs to be done. For example, maybe there's still some slaughtering that must be done or what. So it's going to depend on the facts of each case and also on the custom. What is the living custom in that community? For example, if Mpho and Lerato, if Mpho and Thabo and say that we come from this area, and then when we enter into a customary marriage in this area, we don't do this slaughtering, we don't do all of these things. After lobola has been paid, we just let's say we just drink tea, and after that we regard this as a customary marriage. If in that community is how they do things, that process can be regarded as a customary marriage. So as we are speaking now, there is not really there is not really a yes answer or a no answer, because each and everything will depend on the facts of each case. But what you must know is the handing over of the bride is now no longer necessary, unlike previous judgment, which had said that for a marriage to be valid, the wife must be handed over, or else there is no valid customary marriage. Okay. Does anybody else have a question? I think I saw the hands of Darlene. Darlene, do you have a question? Okay.
Yes.
Okay.
Thank you. I just wanted to know regarding, I mean, during the divorce proceedings,
Yes.
the wife can apply for interim relief, which I think it's Rule 43. Is that
Yes.
only applicable to the first wife, or can the second and third wife also apply for it if they are going through divorce proceedings?
Any spouse who's in a valid customary marriage can enter into it, but the courts have held that even if there is a dispute as to whether there is a valid customary marriage or not, a spouse can apply for Rule 43 High Court, and then in the Regional Court is Rule 58. So anybody can apply, including the husband.
Thank you.
Okay. I saw Zungu, Nkosi Zungu. Zungu, please unmute yourself. Nkosi Zungu. Okay, we are moving
Yes,
on.
ma'am.
Okay.
Yes, ma'am. I wanted to support your statement, the issue of the particular circumstances of the case or case by case basis. Because, for example, you might find that the only thing that is holding the ceremony from taking place maybe is the availability of the parties, you know. Maybe the mother of the bride is not well, and that is only that factual circumstance that is holding the ceremony from taking place. So the court obviously will look at what is to the advantage of all the parties, what is to the advantage maybe of the kids, if there are kids that are involved. So if it was a question of the availability of the parties preventing the ceremony from taking place, obviously the court will come to the conclusion that that marriage is valid in my view. So I support you when you say that it will be a case by case basis. Thank you.
Okay, thank you. Palisa?
Okay, ma'am, I just want to ask something. So, two questions. If in the double HP case, if they did not do the celebration, would the case would have taken a different turn in terms of not validating that the marriage was valid? Okay. And number two, someone who is Zulu married in KZN, as I would, maybe the Zulus will correct me, I would believe that the process of umembeso would render the marriage valid, or it does not matter on that part. Like you saying, it depends geographically in the community as to where is it, where you are married. Would you have any idea as to, in terms of the Zulus, how would the marriage be validated? Thank you.
Okay, it depends where you live, and the court look at what we call a living customary law. That is what are the parties and the community currently practicing. So even in, let's say, in KwaZulu-Natal, and a high number of spouses still do the umembezo and other customary processes. If a certain family, they decide that we are not going to do that, let's say for financial reasons, but they decide that we'll just have an informal and a non-celebratory customary marriage, that will also still be allowed, as long as in court it can be proven that they, the families themselves, agreed that all these other customary processes, we do not have to enter into them. But as the family, we bless the couple and we did impepo and all those smallanyana and then informal processes that can also lead to a valid customary marriage. But as I said, the court will look at the specific circumstances of that case. So although living customary law says look at what is currently being practiced by the communities in the society, that does not mean that if there are parties who did not follow the specific process, that marriage will not that marriage will not be rendered a valid customary marriage. So it is up to the parties themselves. Is one party says we do not enter into a valid customary marriage, it is up to the other party to prove that we entered into a valid customary marriage, even though we did not comply with all the processes that are done by the Zulus or even with living customary marriage. Also, the families can just look at what they do just in their homes, that when we enter into a marriage, we don't believe in wasting money if they use such words that, you know what, instead of spending money and doing this ceremony, instead of spending money and then buying cows and then slaughtering, we just go to the butchery, just buy some meat and then just do a smaller thing, and then the monies which were supposed to be used for the celebration, we give it to the parties so that they can start their life, they can buy their house, they can buy all of those things. So those are some of the things that the court take into account, that okay, the parties did not do this, but can we really say they did not enter into a valid customary marriage? And on the HAP, I really wouldn't know if only lobolo was paid and nothing else was done, whether the court would have said there is still a valid customary marriage, because for the wife, that small celebration or that small ceremony that was held at her family's place played a very key role in making sure that she is regarded as a wife. As a wife. Having said that, remember I said there are 3 requirements. The first requirement of age, that one is not a problem. The other requirement which is problematic and which is linked to the third requirement is the one of consent. You know, most of us are aware that a high number of Black spouses or of Black people, when they enter into a marriage, they will do the traditional marriage, and they will do what we commonly call a white wedding. And you must note that a white wedding is normally a process that leads to a civil marriage, and you enter into a marriage in terms of the Marriage Act. And there is the customary marriage, which is regulated by the Customary Marriages Act. So if the parties do these 2 processes, and one party says we entered into a customary marriage, and the other party will say, but our intention was not to have a valid, to enter into a customary marriage. This was the first step towards us entering into a civil marriage. This causes usually a problem, and this is again another requirement which the court look at it on a case-by-case basis. There has been cases or judgment whereby the customary law process was done, but the court held that this is not a valid customary marriage because the parties did not agree to enter into a customary law marriage. Instead, they were just doing that to appease the ancestors, to just give respect to their family members. And there are also judgments whereby even though the parties agreed that we are going to enter into a civil or a marriage in terms of the Marriage Act, because of the customary law process that were held, the marriage was declared to be a valid customary marriage. So this again, it depends on a case-by-case basis. Unfortunately, customary marriages at the present moment, they're a bit of a challenge. They're a bit of a challenge because one cannot say for sure that because lobola was paid for you, indeed, you are going to be regarded as you are in a valid customary marriage. It will depend on how you present your case at court, and if the other person or the other spouse, if they are not able to convince the court that a valid customary marriage was not entered into, or a valid customary marriage was entered into, the judge or the court will rule in the favor of the one who managed it to convince a court, not beyond reasonable doubt. But yeah. Okay. Zanele, you are the one who just asked a question, right? Zanele?
It's Palisa.
Oh, it was Padisa. Okay, thank you. Zanele, I hope you are covered, Padisa. Zanele?
Yes, ma'am. Yes.
Okay, Zanele?
Ma'am, I do have 2 questions that I need to ask. Can you hear me?
Yes.
Okay. Let's say, just like you've said, that Thabo and Palisa are married, customarily married. But in my scenario, this is what happens. Thabo only pays lobola for Palisa and half of the lobola. Then after that, they go to court and then they sign. Will it be valid as a customary marriage or not? Or it will be a civil marriage? And then after some time, Thabo tells Palisa that he wants to take a second wife. And then that second wife, he pays full lobola, and then all the necessary agreement and the ceremonies happen. So which marriage will be the civil one? Will it be between Palisa and Thabo, and then Thabo and the other wife, will it be the customary marriage? How will that happen, ma'am?
Okay. Firstly, we need to note that a man, although lobola is part and parcel of customary marriages, a man does not necessarily have to physically pay the money for the marriage to be declared to be a customary marriage. Just a declaration that I will pay lobolo can actually lead to a valid customary marriage. And regarding paying half lobola and going and signing at court, it will depend on whether the parties signed a civil marriage or signed a customary marriage. The marriage certificates are the same. The only difference is one is written civil and one is written customary. So let's assume that they entered into a civil marriage. So if they entered into a civil marriage, the husband cannot take another wife. If they entered into a customary marriage and the husband or the wife goes and enters into another marriage, but this time a civil marriage, the civil marriage will be null and void. But if the husband enters into another customary marriage, even though he has a marriage certificate that says customary, the subsequent wife's marriage will be valid if the legal requirements of entering into a customary marriage were complied with. But the marriage regime will automatically be out of community of property unless if the husband complied with section 7 subsection 6. So just to sum up your answer, it will depend which marriage regime did the parties enter into when they went to Home Affairs, and then that one is the one that's going to determine who is actually the valid spouse or not, and then secondly, which marriage regime is going to regulate their marriage. But you must know, or you must remember, that if you go and sign at the Department of Home Affairs without an antenuptial contract, the marriage will automatically be incomplete. But let's say it's the husband who has or who is in an existing unregistered customary marriage, and because it is unregistered, Home Affairs does not have a record that shows that the husband is married, and the husband goes and enters into a civil marriage with another wife, and they have a marriage certificate. This civil marriage will be null and void because the unregistered customary marriage was entered first. But if the husband enters into a civil marriage first with this wife, and then goes and enters into an unregistered customary marriage, that customary marriage will be null and void because there is an existing civil law spouse. So in order to determine who is the legally recognized valid customary law spouse, the answer is it is the one who was married first and who was legally married first. That will give you the answer. Okay, are you covered, Zanel?
Yes, ma'am, thank you.
Okay. Lastly, we'll take Alex. Alex, please unmute yourself.
Thanks very much. I just want to clarity on the lobola issue. I think that will be my last question. The lobola issue. If for whatever reasons the lobola is paid, all processes were followed, but unfortunately, that kind of marriage has not been registered with the Home Affairs. When you go for a divorce for whatever reasons, are we into the court has to nullify that particular arrangement that was made before, even though it was not registered with the Department of Home Affairs?
Okay. As I stated, customary marriages, whether unregistered or registered, have to be terminated by a court of law. In an unregistered customary marriage, you firstly need to prove that you are in a customary marriage before the court can terminate a marriage. Remember, for in the divorce court or in the high court, before the court can terminate the marriage, the court firstly needs to know, or you need to prove that there is an existing marriage. So the marriage certificate is proof, conclusive proof that the parties are married. If there is no marriage certificate, you prove by submitting affidavit, submitting copies of photos of the customary marriage celebration, and if there is a dispute, you have to bring in witnesses. And that is how currently the courts are dealing with it. In terms of our court system, both the High Court and the regional courts now have the powers to terminate marriages, or the High Courts have always had them. The regional courts have the powers to terminate customary marriages, but most magistrates are reluctant to actually adjudicate matters where there is an unregistered which involves an unregistered customary marriage. So what the courts usually do is they will advise the parties to go to Home Affairs, register the marriage, and then come back to court and conclude a termination of the divorce or of the marriage. Please note that this is something that they are doing themselves, but it's not really regulated by law because there is no provision in the Divorce Act or in any other act which requires the magistrate to firstly instruct the litigant to go and get to go and have the marriage registered first, and then come to court and finalize the divorce. Other magistrates, they do go ahead with terminations of unregistered customary marriages, but we are now seeing a high number of magistrates who are unwilling to actually entertain it. And if you don't have a copy of the marriage regime, of the marriage certificate, they will just tell the parties that, you know what, they just need to go to the High Court. The High Court does not require the parties to submit the marriage certificate, but they require the parties to prove that they entered into a valid customary marriage. If you cannot prove that you entered into a valid customary marriage, the court will not adjudicate the divorce. Okay, thank you. Daniel van Wyk.
Hi, ma'am. I have to go now, so I just want to make sure of one thing. I saw on our time schedule that the exam for this module is on 3 December. I just want to make sure if that is correct.
Okay, I cannot confirm that at the present moment. All I can say is please be on the lookout for announcement. Then if there is a possibility that the date may change, but I don't want to confirm anything at the present moment. So just please on a daily basis, in the morning and in the evening, just make sure that you check the announcement section so that you know exactly on which date you're going to write the exam.
Okay, thank you, ma'am. Thank you for the class. Goodbye.
Okay. Okay, students, as I said at the beginning that I did a summary of customary marriages, and I've divided them regarding customary marriages that were entered into before and after the commencement of the Act, and then information regarding registration. Please remember that customary marriages remain to be legally recognized even if they are unregistered. And the period of registration has been extended now up until 30 June 2024. And oh yeah, here non-registration does not invalidate marriages. And then here I've summarized the patrimonial consequences of a customary marriage, monogamous customary marriage, polygamous customary marriages, and here alteration. If you are married in community of property and you want to change from in community of property to out of community of property, and then here is termination of a customary marriage by divorce, termination by death, and then here is the coexistence of a customary marriage and a civil marriage or a civil union. Remember, civil marriages cannot coexist with any other marriage, and then they are monogamous. Customary marriages the same, cannot coexist with any other marriage system, but customary marriages are not monogamous. And then here I just did a summary of the important cases that actually changed the position in customary marriages. Yeah. And lastly, students, good luck for your exam. Good luck as you are studying. As I said, please on a daily basis keep on checking the date when you are going to write the exam. But in the meantime, just keep on studying, and yeah, all the best for your exam. We have come to the end of today's session. And if you have any other questions, or if you want to speak to me privately, feel free to send me an email. I will write my email address on the chat system. And yeah, all the best and goodbye for today. Bye-bye.
Goodbye.
Bye-bye.
Bye, ma'am.
Bye.
Thank you very much. Thank you. Bye-bye.